when a founder or future founder is in the idea phase
Mm-hmm.
and he has no money to uh, develop a product, let alone uh, pay an attorney to protect his idea, what does he have at his disposal to protect his idea? Or is it okay for him to talk about his idea in the hopes that nobody takes his idea?
That an attorney would generally tell you, no, that's not okay.
Yep. Yep.
And there's very little to help folks
Yep.
like that. Let me start with this. I'm going to say it 3 times because it's really, really, really important. Intellectual property law, not just patents, in general, intellectual property law is stubborn. Intellectual property law is stubborn and it does not care about your feelings.
Yep.
It is very, very, very strict. Intellectual property law requires you to timely do whatever the law requires you to do. Again, IP law requires you to do things when the law wants you to do it. So if the law says you have 1 year to file this thing, you only have 1 year. And I'm going to go into the specifics right now. I'll give you an example. Using that hypothetical you just mentioned, somebody has an invention and they have little money to take care of it. What they might want to do is find a local university, and you might actually call the office that I used to work at, OED, the Office of Enrollment and Discipline at the USPTO. The phone number is 571-272-4097. That number again is 571-272-4097. And ask how to find the list of universities that deal with patents or trademarks. If you have a patent, you deal with the patent. If you have a trademark, then you ask for the trademarks. That's actually online as well. So you might want to Google, let me try it myself. I think I think the Google is, the search will be something like USPTO law school program. Yeah, USPTO law school clinic certification program. And that will give you a list. So if you Google that, the URL is long, but the Google is short. So you just type that USPTO law school program, and you're gonna find the law school clinic certification program, and you're gonna find different a list of different law schools with their emails and whether they do patents or trademarks and the region that they do, all of the states, patents only, whatever. And you can email them. Keep in mind that these are professors watching over students, right? So the students are going to try to help you out. And if they have a conflict or if they don't have the time, they might not be able to help you. Depends on the semester, right? And the point that they are in time. But that might be really helpful. The other option is you can also call OED and ask instead of this for the pro bono program. And the states have different resources. Let me see what happens if you type USPTO pro bono program. Pro bono, patent pro bono program. So yeah, try that as well. You can type USPTO pro bono program. I would say try everything and see what's the best option. Talk to everybody, talk to more than one school, and be mindful once you talk to third parties, even with the best of intentions. If you don't have a non-disclosure agreement in place, if you don't have a document protecting you, then you are giving information to a third party, and that starts whatever information you give. If you give like the inventive concept away, if you give away the invention, if you explain it in that process, then whatever you gave out, you have 1 year from that moment to file a patent application for that. But that's only in the United States. Outside of the United States, some countries will say you disclose, you don't have access to a patent grant after disclosure. So you might lose international rights from the get-go. What you rather do instead is get those non-disclosure agreements in place. If the patent pro bono program, it's not good enough, if you're going to do something in a week or less and you just don't have time to call law schools, another option that you have is to find 100, I think it's 125 or $150, I forget the exact amount, but you can file a provisional patent application and take the documentation. This is like a last minute thing, and I suggest people don't do this because it's sort of like a waste of money. They think, oh, I have a provisional. Provisionals are actually just as tough to write up as a regular application, if you're gonna do them right. But if you don't have time, in theory, you could collect your thoughts, collect the invention, explain it, with drawings and everything, and put it into a provisional. But the provisional is still is still going to require the formalities to a certain extent that a normal application has. And here's the thing: to benefit from a professional application as to their content, in a non-provisional, the content has to match. So if I did not fully fledge out the invention in the provisional, whatever was left out, I don't get the benefit of that earlier filing date in the non-provisional application. Did that make sense?
Yep.
So you have to fully explain it. And if you're not fully fledging out the invention there, then and you might often think that you do and that you are explaining, but attorneys usually have a way of thinking that we make less assumptions, we explain things more, we know what to say and what not to say. So you might find yourself filing a provision. I've seen this provisional applications that actually do more harm than good. And you want to be very careful with what you write. You might want to do Google or YouTube research, or just talk to an attorney.
Udemy.
Yeah. I'm sorry.
Udemy.
Yeah, Udemy, maybe. I think they have some courses. Maybe they do. Maybe I should make a course in Udemy to help
There
people
you
out.
go. Yeah.
But for the most part, you want to talk to an attorney and try to figure out or get some help, because these things are tough. It will be like me trying to fix a car. I know nothing about changing oil in a car.
Mhm.
This is what I do, not that. So in the same manner, if you can try to find someone to help you out with this process, because it can be complicated. And I know we're running out of time, but I also want to touch on the business side of it, like how this plays out within the whole thing, because this might be a cornerstone of a business, especially if you're in the technology or in the innovation industry, where whatever, even a hot dog stand can have a design patent application protecting the ornamental aspects of it. So, or a branding issue that you want to protect. And so going back to that hypothetical of somebody doing this, you might want to go to SBA, and the Small Business Administration has uh, small business development centers. If you have something that involves technology, they have small business technology development centers. So they're usually tied to nonprofits or universities, and they are like the outreach branch of the SBA itself. The SBA kind of like
Mhm.
helps these uh, development centers become available with experts in finance, economics, technology, PhDs, and they can give you guidance as to how to put a business together, regardless of the type of business, because they have so many different experts. And uh, they are all over the states. You might want to talk to them in terms of like in a 1 minute explanation of how I see this is the best way to put it together is um, you would have to make a balance between developing a business plan and just getting things done to begin with, right? Like you can plan forever and get some type of analysis paralysis, like what am I doing here? So
Yes.
SBA or just your friends, you know, other people can tell you, hey, stop like spinning wheels, be careful with those interactions, even with SBA. there might not be patent experts, and if you disclose inventions themselves, there might be some issues with conveying that information to a third party. Um, but putting that aside for a second, when you convey what you're trying to do to them, they might give you guidance as to what to tackle first, because every business is different. But for the most part, in the technology side, because of that timeliness requirement with patents and with technology and getting it protected, I would say that for the most part, every time I see businesses, they are usually late with this, and it's almost inevitable because people do not know about intellectual property. It's not what they have in their minds. They're thinking more about helping their customers, launching. Sometimes it's more valuable to be first in market rather than getting a patent protection. Think about Uber versus Lyft, right? Uh, so Uber will be in a much better position with a patent, right? Like something and I'm not saying that they would have been able to obtain a patent for their main product, but I'm pretty sure I've never looked at it, but I can imagine that they are trying to get patent protection on the different solutions that that are behind their product. That
Yep.
maybe the one click thing, maybe showing information while you're trying to do uh, uh, finding a car or something with their product.